Clarence Thomas doesn't lose his patience often. For decades, he sat on the highest court in the country and said almost nothing during oral arguments. Silent, watching, letting other justices fill the room with questions while he studied every face, every answer, every hesitation. That reputation made what happened next so extraordinary. Because when a lawyer stood before the Supreme Court and started dancing around a direct question, Thomas leaned forward. And the words he said next froze every lawyer in that room. I mean, it's your product. 5 words. No anger, no theatrics. Just 5 words delivered with the quiet certainty of a man who has heard every legal dodge imaginable and is no longer willing to pretend he hasn't. And the moment those words landed, every person in that courtroom understood something had just shifted. So what pushed Clarence Thomas to that moment? What did this lawyer say or refuse to say that finally made the most silent justice in modern history speak up? Because this wasn't random. This was the product of a specific exchange, a specific set of questions, a specific pattern of sidesteps that Thomas had been watching build for several minutes before he'd seen enough. And when you understand exactly what was being avoided and why, you'll realize this moment wasn't just a courtroom confrontation. It was a window into something much bigger about how powerful institutions answer for what they create. Here's what you need to know first. Supreme Court oral arguments are not like what you see in movies. Justices don't grandstand. Lawyers don't make speeches. The format is brutally efficient, 30 minutes per side. Questions come fast. Answers are expected to be precise. There is no room for carefully constructed ambiguity. When a Supreme Court justice asks you a direct question about your client's product, the expectation is a direct answer, not a redirect. Not a pivot to case law, not a reframing of the question into one you'd prefer to answer. A direct answer. That is the baseline of the room. And this lawyer failed to meet it, repeatedly. The case itself centered on a question that has been building for years inside American courts, whether a company can be held legally responsible for the foreseeable consequences of what it puts into the world. Not the accidental ones, the foreseeable ones. The ones that internal documents show the company understood were likely before the product ever reached the public. This is the terrain where the most consequential corporate liability battles of the modern era are fought. And it's terrain where lawyers are trained to introduce complexity wherever directness might be damaging. The lawyer was good, technically skilled, strategically prepared, and clearly knew the pressure points of the case she was defending. She navigated early questions from other justices with the fluid confidence of someone who had rehearsed every possible line of inquiry. She redirected effectively. She introduced legal distinctions that slowed momentum. She did what skilled advocates do, which is make the simple complicated and the complicated technical enough that the non-lawyer in the room loses the thread. But Thomas wasn't losing the thread. He was watching it, quietly, the way he always does. The exchange that produced the moment started with a question that was, by Supreme Court standards, remarkably direct. Thomas wanted to know whether the company had specific internal awareness of the harm its product was causing before distribution. Not legal awareness, actual awareness. Did they know? The lawyer's response was a masterclass in structured evasion. She introduced the question of what awareness means in a legal liability context. She cited relevant precedents. She acknowledged the general concern about corporate accountability while immediately pivoting to the specific procedural posture of this case. It was smooth, it was practiced, and it answered nothing. Thomas let her finish. He didn't interrupt. He didn't cut her off mid-sentence. He let her complete the full architecture of her non-answer. And then, in the silence that followed, he said it. I mean, it's your product. Not as a question, not as a legal argument, as a statement of fact so simple that the sophistication of everything she just said collapsed around it. Your client made this thing. Your client put it into the world. Your client had information about what it would do. The question isn't complicated. Why is the answer? The courtroom reaction was immediate. Other justices glanced over. Court reporters stopped typing for a beat. Even the lawyers at the opposing table couldn't fully contain the recognition of what they'd just witnessed, because Thomas hadn't just asked a sharp question. He had stripped away the procedural scaffolding that the defense had spent the entire argument constructing. In 5 words, he returned the entire exchange to its human center. A product, a company that made it, people who were harmed. The rest is detail. What the lawyer did next is what lawyers in impossible positions are trained to do. She acknowledged the point, partially, in a way that appeared responsive without actually conceding anything. She agreed that yes, the company produced the product. She agreed that product liability is a legitimate area of law. Then she immediately returned to the specific legal standards she argued should govern this case. It was professional, it was skilled, and every person in that room could see exactly what it was. Here's what the coverage of this moment keeps missing. Thomas's intervention wasn't about scoring a rhetorical point. It was about something the Supreme Court is confronting with increasing urgency: the gap between what companies know and what they admit to knowing. The gap between the product as designed and the product as it operates in the world. The gap between the technical definition of liability and the human experience of harm. That gap is where this case lives. And that gap is what the lawyer's sidestep was designed to protect. Thomas has seen that protection strategy across more than 3 decades on the court. He has watched it evolve from simple jurisdictional arguments into multi-layered, precedent-dense legal architecture that can turn a clear question into a 40-minute seminar on tort law. He understands the genuine difficulty of drawing lines in product liability cases, but he knows the difference between genuine complexity and manufactured complexity, between a hard question and a question made hard on purpose. And what he heard in that exchange was the second kind. The broader stakes extend well beyond the specific facts at issue. What the court is being asked to decide touches on how accountability works for companies that produce the goods and services that define modern life. Not just physical products, digital products, algorithmic systems, platforms, tools that shape behavior and enable harm in ways their makers understood before the tools ever reached the public. The question Thomas was pressing is the foundational one underneath all of those cases. If you made it and you knew what it could do and you put it into the world anyway, where does your responsibility begin and where does it end? The lawyer didn't want to answer that directly. Thomas wasn't willing to let her not answer it. After the arguments concluded, legal observers split along predictable lines. Defense-side analysts praised the lawyer's technical command and argued that Thomas's comment, while dramatic, didn't represent a substantive legal position. Plaintiff-side observers said the exchange captured exactly why product liability doctrine has failed to keep pace with modern corporate behavior. Both assessments contain truth, but neither fully captures what made that moment significant. What made it significant was the visibility of the gap between the question Thomas asked and the answer he received. Because in a room full of the most sophisticated legal thinkers in the country, a single plain-spoken observation cut through everything. It's your product. You made it. The court is asking you what you knew about it. And the refusal to answer that question directly is itself a kind of answer. One that Thomas, after 30 years of silence and watching and waiting, finally decided was worth saying out loud. The ruling is still pending. The legal questions will take months to resolve. The case will generate opinions that shape corporate liability doctrine for years. But the moment that will be remembered, the moment lawyers who were in that room will describe for years to come, is 5 words from a justice who almost never speaks, and the silence that followed. And what that silence said about everything the lawyer had decided not to.